Everybody ready to roll?
We are, Judge.
All right. Let's be on the record in case number 2020-CR405, captioned State of Kansas versus David Heck. Would the parties announce their appearances, please?
May it please court, the state appears to Maurice Brewer.
May it please the court, Daniel Heck appears in person in custody and by counsel Zach Anthony.
I am hearing nothing.
From me?
From anybody? I can hear Zach.
Let me check my speakers. Everybody take a breath here. Huh.
You're playing music now.
All right, let's try this again. Someone say something.
Can you hear me?
This
I'm
is
talking
Zach.
now.
Nothing.
I can hear everything. Can you hear us, Judge?
I think we can all hear each other. Can't hear us.
You can hear us?
Everybody else hear everybody except for me?
Yes.
All right.
Yep.
I had scratchy speakers earlier today, and they told me to turn off audio enhancements. That's the only change I've made, which must be stopping it. So I'm going to turn them back on, see if it helps. Now, someone say something.
Can you hear me?
Hello.
Let me try headphones, see if those help. Now somebody?
Can you hear me?
Hello.
Nothing. I am going to leave the meeting and I'm going to make Zach the administrator and then come back and see if it helps. Okay.
Can you hear anything now?
Yes,
You can?
I can. I can hear you.
Good.
I have no idea what's going on here. All right. So I called the case. Let's start that all over again. Calling case number 2020-CR405, captioned State of Kansas versus David Heck. Would the parties announce their appearances, please?
May it please court, the state appears to Maurice Brewer.
May it please the court, Daniel Heck appears in person and by counsel Zach Anthony.
All right. We are here set down today for a plea hearing. Mr. Heck, in order to take up the plea, I'm going to need to ask you a bunch of questions. To do that, I need to have you sworn in. So if you could raise your right hand, my court reporter will swear you in.
You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
All right, now, Mr. Heck, if I ask you something and you don't understand, don't take a guess at it. You tell me that you're not understanding what I'm asking, and we'll talk about it until we both are sure we're on the same page, okay?
Yes, sir.
Likewise, if at any time during this hearing, you want to talk to Mr. Anthony in private, I can make that happen. They're called breakout rooms, and I basically send you and him to there, and you can talk without any of us hearing it, okay?
Okay.
How far did you go in school, Mr. Heck?
I have college education. I
All
don't
right.
have a degree, but yes, I'm college educated.
Read and write okay?
Yes, sir.
Now, I know you're in custody, but as you sit here today, are you under the influence of any alcohol or drugs or prescription medicine that might cloud your mind, keep you from understanding what you're doing?
No, Your Honor.
Feel like your mind is clear today?
Yes, sir.
All right. Do you understand what you're charged with?
I do.
And you know that you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have a right to a jury trial on these charges. You understand that?
Yes, Your Honor.
All right. At that trial, Mr. Anthony would be able to help you. He would cross-examine and confront all of the state's witnesses. He could call any witnesses you wanted called, and if they didn't want to come to court, he could use the subpoena power to make them come to court. Do you understand that?
Yes, Your Honor.
At that trial, you'd have a right to testify, but you'd also have a right not to testify. And if you decided not to testify, the state couldn't use that to argue that you must be guilty. You understand that?
Yes, sir.
And finally, if that trial happened and at the end of that trial you were found guilty, you would have the right to appeal that conviction to a higher court. If you didn't have the money to do that, a lawyer would be appointed to do it for you. Do you understand that?
Yes, sir.
So you know that if you go forward with this plea today, you're going to be giving up all of those rights that I just talked about, and there's not going to be a trial of any kind in this case. You understand that?
Yes, Your Honor.
All right. Any questions about any of those rights you and I just went over?
No, sir.
All right. I have received from Mr. Anthony a copy of the plea petition, and hoping this works, I'm going to share it with you right now on the screen. Tell me if you can see that.
Yes, I can.
All right.
It's
I'll
starting. Go ahead.
I'll go up to the top there. You recognize that document?
Yes, sir.
All right. Is that the plea petition that you and Mr. Anthony went over?
Yes.
It says here that the agreement in this case is that you're going to plead guilty to the first count, which is fleeing and eluding, and the other counts are going to get dismissed. They will agree to recommend a mitigated term and reserve their rights to comment regarding disposition, which I suppose means whether or not you're granted probation. Is that your understanding of the plea agreement?
Yes, Your Honor.
Yours as well, Mr. Anthony?
Yes, Judge.
And Mr. Brewer?
Yes, Judge.
All right. So you understand that I see in there that it talks about recommendation as the sentencing. I'm going to listen closely to what everybody has to recommend and argue about sentencing. But at the end of the day, I'm not bound by anybody's agreements, and I can sentence you to anything that the law allows me to. You understand that?
I do, Your Honor.
All right. Has anybody promised you anything other than this plea agreement that I just went through?
No, sir.
Anyone place any force or threats against you to make you plead guilty today?
No, Your Honor.
All right. What do the parties believe Mr. Heck's criminal history to be?
I believe his criminal history to be an A, Your Honor.
All right. Is that your understanding as well, Mr. Anthony?
Yes, Judge.
All right. So what they tell me, Mr. Heck, is that your criminal history is unfortunately about the worst that we can have as far as scoring purposes goes here in Kansas. So what I have to tell you today is what the maximum sentence that you're looking at could be. Do you understand that?
Yes, Your Honor.
The maximum that anybody can get for this crime is 17 months in prison and a fine of $100,000. That sentence would carry 12 months of post-release supervision. Do you understand that?
Yes, Your Honor.
All right. Any questions about anything that we've gone over today?
No, sir.
Knowing all of those rights that we talked about and everything, you still want to go forward with this plea?
Yes, Your Honor.
All right. Before I ask you how you plead, I'm going to go down here where it says sent, signed, and it looks like it's typed in signed. So you didn't have an opportunity to physically get this document and sign it. Am I correct in that?
No, but I did read through the whole thing.
Okay. And so you approve Mr. Anthony putting that in there that's showing that you
Yes.
basically signed it. Okay. All right. So given that, as to count one, fleeing and eluding, a severity level 9 person felony, how do you plead, guilty or not guilty?
I plead guilty, Your Honor.
All right. I'm going to ask Mr. Brewer to tell me what he thinks the evidence would be if there was a trial in this case. I want you to listen closely because when he's done, I'm going to ask you if you agree that that's what the state's evidence would be. Mr. Brewer.
Yes, Your Honor. The facts would be that on or about June 12, 2020, Officer Brendan Hedrick, a Bonner Springs police officer, was on duty in uniform and driving a marked police car. At Kansas Avenue and Commercial Avenue in Bonner Springs, Wyandotte County, Kansas, Officer Hedrick saw a red 2003 Honda Accord with a broken tail light. Officer Hedrick attempted to stop the car for the broken headlight at Commercial Drive just north of Kansas Avenue. When he activated his lights and sirens, the Honda Accord took off. The following happened on the pursuit. The defendant continued on Commercial Drive before making a legal turn onto northbound K7 highway against the designated flow of traffic. The defendant then continued northbound on K7 highway past Speaker Road. He was going approximately 70 miles per hour in a 55 mile per hour zone. The defendant then went northbound on K7 highway, failed to stop for a red light at North 130th Street.
Sorry, Maurice.
Going too fast?
Yeah.
Sorry.
Pick up in 70 and a 50 mile an hour zone.
Okay. Sorry, I lost my place here.
What happens when you read? People talk very quickly when they're reading.
All right, he was approximately going 70 in a 55 mile per hour zone. The defendant continued northbound on K7 highway, failed to stop for the red light at North 130th Street before turning northbound. While exiting onto North 130th Street, the defendant drove into oncoming lanes of traffic. At the time, no traffic was going southbound on North 130th Street. He then continued northbound on North 130th Street at speeds that were approximately 70 miles per hour in a 30 mile per hour zone. He failed to stop for a red light at State Avenue. He then continued northbound on North 130th Street before turning eastbound on Delaware Parkway. While turning eastbound on the Delaware Parkway, the defendant failed to stop for a stop sign. At this time, his passenger, Genevieve Hayward, exited the vehicle, but the defendant at the intersection of North Delaware Parkway and North 126th Street, the defendant failed to stop for a stop sign. He continued northbound onto North 126th Street, again failed to stop for a stop sign at Parallel Parkway. He continued eastbound on Parallel Parkway with speeds exceeding 90 miles per hour in a 40 mile per hour zone. Ultimately, the pursuit continued until 110th Street and Hutton Road. At that time, officers discontinued the pursuit. This all occurred in Wyandotte County, Kansas. But the defendant then struck a vehicle on Parallel Parkway. At that time, he was apprehended by officers.
All right. Mr. Heck, yeah, I know there was kind of starting and stopping there, but you heard what the prosecutor had to say?
Yes, I did.
Is that what happened in this case?
Yes, Your Honor.
All right, thank you. I will find the defendant has freely, voluntarily, and intelligently entered his plea of guilty. He understands the nature of the charges and consequences of the plea. there has been a sufficient factual basis for finding of guilt to be made, and I do in fact find that Mr. Heck is guilty of the fleeing and eluding is severity level 9 person felony. All other charges are dismissed per the plea. I will order a pre-sentence investigation and continue sentencing pending the receipt of that. I've been setting October 2nd, gentlemen, and I have an 11 o'clock available. Mr. Anthony, how does that look?
October 2nd at 11 o'clock, Judge?
Yep.
That works fine for us.
And Mr. Brewer?
Yes, Your Honor, works for me.
Okay, October 2nd at 11 a.m. We're all good by Zoom again?
Yes, Your Honor.
That would be fine with us, Judge.
All right, I will send out the invite as soon as we're done here.
Judge, may we be heard on bond before we depart?
You may.
Judge, I think the bond in this matter is $25,000. And as I'm clicking over, I just want to make sure I'm not lying to the court. Oh, I just clicked on the wrong thing though. It is, it doesn't show it. Here it is. I'm sorry, Judge, I didn't have the right page up when I said that, and I wanted to make sure I was right. It is $25,000, Judge. Mr. Heck has a long history of living in Wyandotte County, lives in Wyandotte County now. He also has a job, and he has family that's struggling with their health as part of the current pandemic. We are intending to apply for probation, and that obviously was contemplated by this plea agreement. So we were hoping that the court would entertain an opportunity to lower the bond or to ask that Mr. Heck be screened for pretrial release, whichever the court would prefer.
Mr. Brewer.
Your Honor, I would be opposed to a bond reduction or releasing the defendant on his own recognizance. I show part of the reason why he's criminal history A is that he has 3 prior eludings. I believe one of them is an attempted eluding. And then he also has a conviction for aggravated escape from custody. I believe that each one of those shows that he is a flight risk. And this current case also is an eluding case. So, Your Honor, I do believe that due to the fact that he is going to be presumptive, or we believe that he's presumptive prison, and given the fact that his prior convictions show that he's a flight risk, I am opposed to the bond reduction.
Thank you. I'm going to reduce his bond to $10,000 cash or surety. That'll make sure that he has some skin in the game to make sure that he appears for court and doesn't endanger safety. So I'm hoping that that's something, Mr. Heck, that you might be able to make. Here's the important part of that. If you get out, if there's any other problem, I mean, look, the state hasn't agreed to recommend probation as it is, but if you were to get out and you have some sort of issue with reoffending or not appearing for court or anything, then pretty much your lawyer's ability to convince the court that you should be released on probation is very, let's say the bar just got a hell of a lot higher. I think you should be able to do that. You need to have your family member talk to some bondsmen and see if they can get on a payment plan. $10,000 in a cash or surety should be something you should be able to obtain. And I think that fairly reflects the court's concern about flight and danger to community. So I think it's a good a good place to set the bond. So that's what it's going to be, 10,000 cash or surety. And we'll be back here on October 2nd at 11 o'clock in the morning. Other things for our record today?
Nothing from defense.
We are adjourned. Thank you all. Good luck, Mr. Heck. We'll see you in October.
Thank you.
Thank you, Judge.